Good evening, everyone. Thank you for joining us. My name is Brian Oliveira. I'm the interim CEO at New Jersey Pharmacists Association, and I just wanted to take a quick moment to welcome everyone to tonight's presentation. We have two excellent speakers from Frier Levitt that are going to donate some of their time to make sure that we're up to speed on some very critical issues regarding PBM audits and compliance, network compliance. So again, thank you so much for joining us tonight, and I'm excited to listen in to what the speakers have to present. So Benjamin and Harini, take it away. Thank you.
Great. Thank you so much, Brian. I do appreciate that. We are speaking today about PBM audits and network compliance, getting your pharmacy ready for 2026, especially as we approach the new year. We always like to make sure that pharmacies are informed of what's happened in the past year, what audit trends we continue to see, what network trends we continue to see, so that you can ready your pharmacy as you go into the next calendar year. Again, my name is Harini Bupathi. I'm one of the partners here at Frier Levitt in what we call the pharmacy practice group. I've been here about 9 years, and I deal almost exclusively on PBM audit issues, network access issues, terminations, et cetera. In addition to working on PBM related issues, I'll also advise many times pharmacies on the buy and sell side of transactions, especially when it comes to change of ownership issues and other sort of licensing issues. Again, yeah, we have a very extensive PBM team, and we'll certainly get into some of the background of our firm, but most of my work is certainly focused on pharmacy relationships with their PBMs.
My name is Benjamin Youssef. I am a pharmacist attorney in Frier Levitt's Life Sciences Department. I work often hand in hand with Harini, where we also advise pharmacies, healthcare providers, and other stakeholders, like she mentioned. Recently, I've also received my Apexis Advanced 340B certification. Of note, just to reiterate, many of our attorneys here, we have several attorneys who are clinicians, pharmacists, so it helps as well when we, talk about these issues moving forward.
And it's really great to have folks like Ben who have both a pharmacist background and, of course, the a legal background as well, because especially in this space, we see a lot of that intersect, and it's great to have that background. And he's a great resource. Just some housekeeping before we get started. This presentation is obviously very much for information purposes. Obviously, as lawyers, a lot of the advice that we give is really just to clients. And so to be clear, nothing that we say should be construed as legal advice. And so that's just a bit of housekeeping. To the extent that you have an attorney or that you have an issue and you wish to seek an attorney, we highly encourage that you do so on any sort of issues that we speak on today. We ask that you don't rely on any of this information as actual legal advice. And just a little bit about our firm. We are an exclusive healthcare and life science practice, and we represent pharmacies across the country. Obviously, our home base is New Jersey. We also do have an office physically in Newark as well, but we do represent providers across both healthcare and life sciences. On our healthcare side, a lot of the times we're working with physician groups, hospital health systems, group practices, et cetera. On our life sciences side, we represent all sorts of pharmacies, whether that's independent retail, specialty, mail order, physician dispensing providers, pharmacy marketplaces, even wholesalers, manufacturers, et cetera. And we have an extensive team when it comes to both healthcare and life sciences, whether that's transactional, regulatory, litigation, investigations on civil and criminal side. It's essentially, as I see it, really an A to Z service for a lot of pharmacy providers. And so as we kind of get into this topic, like I said, when we're looking forward as to what we can expect in 2026, it's really helpful to kind of see what we've observed in 2025 and also ongoing. Like I said, I've been doing PBM audits for about 9 years now, and a lot of the times the trends remain the same and continue to be persistent. But obviously, we continue to see new things pop up year after year, and it's really important that pharmacies are aware of that PBM audit activity so that they can make sure that they look inwards into their pharmacy practices to make sure that they're being proactive when they do get an audit. And so we'll not only look at key audit trends We'll also look to see what prompts audits, right? Sometimes there are certain audit triggers or investigation triggers, and it really helps, again, for pharmacies to be proactive. And then, of course, we'll also go into what practical, legal, and administrative rights and strategies do you have as a pharmacy provider so that you're ready in the event of an audit, but also in the event that you're faced with any question of whether or not you're going to be continuing in a certain PBM network. It's really important that pharmacies are aware of really what their rights are when it comes to both audits and network issues. And then again, we'll look to see what we can expect in 2026. A lot of the same, of course, will continue. And we do a lot of these webinars for the purposes of making sure pharmacies are proactive and understand exactly what the industry, especially with PBMs, really looks like. And so with that, we'll go ahead and get started on really the basics as to the difference between audits and investigations that we see.
Thank you, Harini. So just as a starting point, we'll first talk about desktop audits versus investigations. So while many use the terms interchangeably, PBMs treat desktop audits and investigations quite differently. Audits review the validity of claims, while investigations often expand into overall pharmacy operations, third-party relationships, prescriber and patient interactions, and marketing practices. Routine audits typically request prescription level documentation, such as the front and back of scripts, also signature logs, copay evidence, and other notes as well. Whereas, so a common trap here would be reading the notice for a desktop audit too narrowly and submitting purchase records only for the listed claims rather than dispensed products during the audit period in general. This can cause a mismatch and produces large inventory shortage findings. So it's vital to read audit letters carefully, capturing all wholesalers, whether primary, secondary marketplaces, pharmacy to pharmacy purchases, and ensuring the wholesaler attestation is complete and accurate. So that's a common element of an audit. Investigations, by contrast, are purpose-driven and focused on suspected fraud, waste, or abuse, FWA. Here, they generally proceed under tighter timelines, reduced extension flexibility, and stricter documentation standards. In our experience at the firm, we see PBMs commonly claim an investigation to possibly avoid, depending on the state, fair audit law requirements that would otherwise apply to an audit. Pharmacies should still analyze applicable fair audit protections and push back where investigation labeling is used to possibly circumvent these safeguards. And we will touch upon this topic later on in this presentation. But now that we've addressed some differences between desktop audits and investigations, let's discuss what can trigger either an audit or an investigation. So in general, pharmacies are often not told the trigger. Actually, PBMs rarely disclose this information and rarely disclose the initiating reason for the audit or investigation, and only later on, if at all, does the basis become clear. While PBM audits are often performed routinely, certain pharmacy conduct can definitely trigger a PBM to perform an audit. So for example, volume of drugs filled. PBMs often monitor the amount of high-cost medications filled by pharmacies compared to other similarly situated pharmacies in that network. If a PBM believes that a pharmacy is filling an abnormal quantity of high-cost medication, they can perform an audit or investigation in order to confirm the validity of these claims. Next would be volume of prescriptions received from local prescribers. Here, PBMs also would take note of what % of the prescriptions filled come from a single prescriber's office. So particularly taking into account the prescriber's specialty and the types of medications being prescribed, etc. If it looks like a majority of a pharmacy's prescriptions are coming from a single office, PBMs may investigate that to confirm whether there is an improper relationship, for example, between the pharmacy and the prescriber. Lastly, here would be volume of prescriptions filled for non-local patients. This would simply mean that PBMs check to confirm whether a pharmacy is regularly filling prescriptions for patients who live far away, particularly where there are other pharmacies closer to the patient's address. PBMs will possibly inquire as to why a patient will choose to have their prescriptions filled at that specific pharmacy that's further away from them, and investigate methods by which the pharmacy came to fill their prescriptions. In general, PBMs typically move from a routine monitoring to an investigation when they see potential indications of FWA, fraud, waste, or abuse. Those indicators often come from three places: complaints from patients or prescribers, referrals from state or federal regulators, and the PBM's own internal analytics flagging outliers in claims, inventory, or copays. When any of these triggers hit, you would expect a shorter timeline, more broad document demands, and a more narrow appeal path. So it's critical to have your documentation organized and your policies enforced, which we'll talk about as we progress in this presentation, before you receive a letter of an audit or an investigation. So, with that said, why is it important to resolve either an audit or an investigation? So, pharmacies should be sure to make every possible effort to resolve audit findings issued against them, regardless of the potential recoupment amount. So, oftentimes, you may have a finding that's a very small amount, and some may think maybe it's not worth my effort to address it, maybe it's not worth potential legal fees, etc. However, audit findings may still result in termination or other disciplinary action, even when there is a relatively small dollar amount at issue. In order to resolve audit findings, pharmacies in general should be prepared to exhaust all appeal and dispute procedures afforded to them under their respective provider agreement and manual, again, in order to prevent disciplinary action being taken. Unresolved discrepancies usually means increased risk of termination. So what happens if you receive a termination notice? You should assess that immediately. You should first say, is this for cause? Is it without cause? When is the effective date? Are there any immediate payment or claim suspensions? And importantly, what are the appeal or dispute path options and deadlines? In general, terminations require urgent action. PBMs will expect you to possibly know and follow their contract or manual process, but the notices themselves may be brief. Where permitted, the pharmacy would submit written appeals and request a dispute resolution meeting. And in those forums, the process would be done to show remediation, training, policy enhancements, system upgrades, etc. And at the same time, we would analyze legal protections, which again, Harini will discuss later, such as any willing provider statutes and state audit laws, even where the PBMs assert FWA exceptions. At that point, if the PBM maintains termination of the pharmacy despite appeals and disputes, the matter can be escalated, possibly, and be prepared for arbitration or litigation. At this point, PBMs require internal dispute steps as prerequisites, and skipping them would actually risk dismissal of the matter. Arbitration is typically faster and more private, while litigation could run several years and might not be as cost effective, but it's a case by case situation with venue and strategy as it varies by the PBM. So, in general, for the termination, you should always be able and willing to address any finding through appeal. And if it gets to the point of termination, be ready to address that as well.
Yeah, and just to add on to that, Ben, right? The biggest thing and the point that we always try to drive home with a lot of pharmacies is that it's always almost great to have the last word in, right, for PBM audits, especially to the extent that it might not be administratively worth it initially to exhaust any efforts to dispute or to appeal relatively minor audit findings. In the long run, there's only benefit to the pharmacy, especially if there are actually um, true issues in the way that the PBMs allege discrepancies, especially, right? Because sometimes audit findings could lead to termination, but also audit findings could be taken collectively. For example, a pharmacy could experience a relatively minor audit, maybe $5,000 at issue in 2021. Then they get hit with something a little bit more aggressive of like 25,000 in 2023, for example, right? And in 2025, a PBM could say, "Hey, we see that you had 2 audits with discrepancies. Perhaps we should consider reviewing your network status." And so it's not so much about the monetary amount; it's also about the types of discrepancies at issue that could lead to a PBM in making a certain decision against the pharmacy. And so whether a pharmacy does it independently or through a third party such as counsel, we can't emphasize enough that it's always good and in the best interest of a pharmacy to certainly appeal audit findings, regardless of the dollar amount.
Yes, thank you, Harini. So now to switch gears slightly, the discrepancies most likely to trigger escalations and terminations continue to be inventory shortages, copay collection, member prescriber denials, and in many cases, prior authorization practices. You can think of these as the big four that tend to occur across PBMs and require disciplined documentation and policy controls. So we'll briefly address each one of them. So as for inventory shortages, those arise when PBMs determine the quantity dispensed exceeds documented purchases during the audit period. However, the root cause here is rarely true inventory gaps. Rather, PBMs decline to recognize earlier purchases, bulk purchases, purchases from maybe accredited wholesalers or not that are not recognized, marketplace acquisitions lacking proper documentation, out of period receipts due to when the point in time reconciliation process. So in general, pharmacies should maintain independent purchase records in addition to the wholesaler reports and keep all documentation and proof of purchase. So of note, some wholesaler systems that we've seen actually have limitations. So what I mean by that is don't rely solely on wholesaler systems for receiving documentation and proof of quantity dispensed or purchased rather, as some may have look-back limits. Next, PBMs continue to actively audit copay collection. And sometimes we find a situation where, for example, a local pharmacist wants to assist someone in the community and possibly waive a very small copay dollar amount as a sign or gesture of being a friendly local community pharmacist. This will land the pharmacy in trouble. In general, written copay policies are required, often required, and PBMs will measure compliance against both their terms and the pharmacy's own policies. So it should be expected for a PBM to demand receipts showing payment method and amounts for each claim, cash deposit logs matching point of sale records to bank deposits, merchant reports that align to individual claims if the payment was through credit card. If copays are not collected, the PBM would then expect documented good faith collection efforts that result in a majority compliance over time. So some of you may be asking, what about financial hardship? So to that point, financial hardship policies must be detailed, consistently applied, and include clear eligibility criteria, patient communications, and again, common theme of documentation. PBMs will increasingly reject evidence of copay collection made after an audit begins, claiming it was reactive rather than in the ordinary course of the pharmacy's business. So it's important that pharmacies should maintain day-to-day discipline around copay practices and being on top of consistently documenting all their efforts. As it relates to patient and prescriber denials, PBMs frequently contact patients long after dispensing to ask whether prescriptions were requested, received, and copays were paid. Sometimes they'll rely on questionnaires or call scripts that can produce inconsistent answers. So it's important to note that PBMs will only then use a minor discrepancy to reject pharmacy documentation. So we are seeing rejections of signature logs for hyper-technical reasons. For example, missing, well, you could have the patient's phone, date of birth, address, name, but if you are missing any of the above or missing something in the prescription, for example, or a signature deemed to be too generic, those are some discrepancies that PBM could use to reject documentation. So again, pharmacies should contemporaneously document patient communication before dispensing, retain point of sale receipts, and when necessary, consider having attestations, just in case there might be a discrepancy, including explanations of how possibly a patient could have a memory lapse or confused, and showing original records to document informed consent and receipt of the product. Finally, it's important to ensure prior authorization involvement is in line with PBM standards. Recently, this has definitely been a hot topic where if a pharmacy aids PA submissions, this can often, depending on the PBM and their policy, it could lead to several instances where there will be a flagged discrepant claim and can often lead to termination. From here, I will turn it over to Harini, who will walk us through a common case study.
Thanks, Ben. And we can just keep the slide up, the other
Sure.
one that you just went over. And it's because I want to emphasize this a little bit to folks on the call. And these are discrepancies, I'd say, that we've seen and we continue to see PBMs allege in audits. Drug inventory shortages being like the most common discrepancy that we see being alleged in audits. I can't say that it's very rare that we'll see an audit or an investigation come through where there isn't a drug inventory shortage come through or being alleged. And the reason is not necessarily because a pharmacy is not maintaining sufficient inventory or anything to suggest that they're not actually dispensing the medication when submitting a claim. It's more so about the PBM not accepting the pharmacy's purchases for documentation requirements, for it being made way too much, like way too prior to an audit period where there might be contractual limitations on the PBM from accepting it, or where there's just, not sufficient documentation to support those purchases, et cetera. So I can't emphasize enough when it comes to drug inventory shortages, in looking inwards, and, we'll go through sort of the proactive measures, but it is certainly, a very common discrepancy that we see, in addition to, of course, patient denials and prescriber denials and copay collection issues. But drug inventory shortages, I say that because that's almost a discrepancy that I think could be more easily proactively addressed in the pharmacy's operations, whereas patient denials and prescriber denials, as Ben mentioned, sometimes we're at the mercy of the memory of a patient for who received a prescription a year ago. And of course, it's always important for you to maintain your documentation, but despite your best practices, it may not prevent denials, patient denials from happening. But it could, drug inventory shortages, copay discrepancies certainly could be prevented based on pharmacy's best practices. And so with that, we'll move to a case study, just sort of to illustrate things when it comes to drug inventory shortages. As we mentioned during an audit or investigation, most often PBMs are looking at your purchase, your prescriptions. But they're also sometimes and often, especially nowadays, conducting an invoice reconciliation of the pharmacy. It's almost like a two-part process of an audit or investigation. Sometimes, as Ben mentioned, folks will think, oh, I only need to submit the purchase records for the prescriptions that issued. No, typically the pharmacy has to submit all of their purchase records for the whole audit period. So one of the instances, right, like if we're looking at this, for example, here, and the reason we say 2024 is because PBMs could go backwards of like 2 years, technically. Depending on the claim, you could expect audits, especially maybe with Medicaid, even going back 5 years. But typically, we'll see PBMs going back about 2 years when they're doing invoice reconciliations, a year and a half to about 12 to 18 months, I'd say, is a typical audit period for invoice reconciliation audit. And so when I say look back periods, it really means that, if you're looking at a certain period in time, was there sufficient inventory in that period of time that the pharmacy purchased to support the amounts it billed and dispensed to patients? Oftentimes the answer is no, because the thought is that you have inventory on your shelf expecting to be dispensed to patients that typically need those medications, right? So in the first section here, when we're looking at the calendar year of 2024, the pharmacy appeared to have purchased, say, 200 we'll say 200 tablets of certain medication. In the same audit period, the pharmacy appeared to have dispensed 100, which means that they have a shortage of 100 units for that calendar period. But in reality, the pharmacy, knowing that prices, for example, are going to go up, and I'm sure a lot of you guys are doing this, especially now that it's December, you know that prices are going to go up next year. You decide to make a bulk purchase or decide to purchase a little bit more than you usually do. And so you actually purchase 200 units. And so do you purchase 200 units between November and in November of 2023 and December of 2023. And then you had your 200 that you purchased in 2024. So in reality, in the aggregate, you purchased 400 units and then you dispensed only 300. And so you had a surplus of it, if anything, of 100 units. Now, the problem that we see here for a lot of folks is the purchase that you've made prior to the audit period. Thankfully, a lot of PBMs do give you 3 months of a grace period. It's hard to say grace, but a grace period of which your purchases would be considered. So, you know, if your audit period is January 2024, they'll let you go back up to October of 2023 to submit any of your purchase records to them for consideration to be able to do their reconciliation. Certain PBMs, however, only give you a month. And that's the issue that a lot of folks run into with certain PBMs, where they only give you a month. So in this case, if a pharmacy had purchased in November of 2023, those purchases may not have been considered in the reconciliation in 2024. And so that would appear to be an inventory shortage, or that's what the PBM would allege, even though the pharmacy did in fact make a purchase in November. Because it's not within 1 month of the audit period, that specific purchase wouldn't be considered. That is the reason where we say pharmacies could certainly be proactive in going through these, in trying to address their inventory audits. Sorry, Ben, I think we skipped ahead. In addressing the PBM, in addressing inventory issues. And the reason is because that certain PBM that only gives you a 1 month look back period also expects that you make notifications of bulk purchases. Bulk purchases is very loosely defined. It could mean a quantity that it takes for you to dispense more than 30 days of, right? So it's very difficult for you to understand what a bulk purchase is, and honestly also for a PBM. I've seen instances of where pharmacies make a bulk purchase notification to a PBM only for the PBM to say, no, it's not going to be considered, right? And so when we talk about bulk purchase notifications, it's almost a situation where it may be better for a pharmacy to just make a notification if they know that they're making more of a purchase than usual, just so that that purchase, when you make that bulk purchase notification, the PBM will consider it in the event of an audit. And so it's really important that you understand your contractual limitations, and which PBMs do give you, say, a 3-month grace period versus a 1-month grace period, with the expectation that you also make bulk purchase notifications. And so moving on to the next case study, and I think we had actually kind of, again, gone through some of this. Again, when it comes to that bulk purchase notification, this is where it comes to play, is where PBM has refused to accept pharmacies' bulk purchases because they haven't made notifications or allegedly haven't. But we have been able to work with the pharmacies in the past to obtain copies of the notifications that they've made to PBMs that explicitly indicate, hey, I'm making a purchase of X amount. Here's the information on the purchase that I've made. And that's it. That's about it. And we've used that simple notification as a means of resolving inventory shortages. And so it's really important, like I said, if in the event that you are required to make a bulk purchase notification, that you go ahead and do so. Again, other reasons why we see inventory shortages more commonly and most commonly is just documentation, record keeping issues, right? If a pharmacy's wholesaler closed down since they had made those purchases, but the pharmacy didn't maintain independent records. If a pharmacy made a purchase from a pharmacy marketplace, right? Those are other audit issues that we'll see, and that we'll certainly get into, especially as we go to sort of the 2025 audit observations that we've seen this year, and that we can expect to see into 2026 as well. when we talk about things that we've seen a lot this year, and like I said, that we can expect to go into next year, we certainly see a lot of instances of escalations to boards of pharmacy. A lot of the times, what we'll see, especially with some certain PBMs, is that unresolved audit findings could actually turn into a complaint to the board of pharmacy. In fact, a lot of audits and audit findings do end up, especially investigations, do actually make their way to boards of pharmacy. It's just a matter of whether or not a board of pharmacy decides to pick it up as a matter of, something that they want to otherwise look into and investigate and, review the pharmacy for. So it is, again, really important to make sure that we're, again, going back to our original point, appealing audit findings wherever possible. The other thing that we're seeing a lot is increased scrutiny into your marketing relationships. As part of investigations, we'll often see certain PBMs actually send out marketing questionnaires to pharmacies, inquiring as to whether or not they have any third-party marketing relationships, or like, hey, we noticed that you're getting a lot of prescriptions from this prescriber, or a lot of prescriptions for these certain medications. Do you have any marketing tactics? And so there's a series of questions that they'll otherwise ask. Interestingly enough, those questions have not changed for 8 years now, and hopefully that PBM doesn't realize that they haven't changed those questions. But sometimes they'll ask pharmacies of their marketing or third party relationships, and so it's really it shouldn't be. Pharmacies should expect to be able to answer those questions, to the extent that they use third-party marketing relationship marketers, or to the extent that they have in-house marketing as well. PBMs could expect Pharmacies could expect that PBMs will look into that. The other thing that they may look into is third-party relationships that might be marketed to the pharmacy, or like companies that might be marketed to the pharmacy as folks that might be streamlining their operations, but almost sort of then operate as like a third party hub relationship of sorts that then sends prescriptions to pharmacies. We've just seen a lot of folks get kind of mixed into different companies, not realizing that some companies have been, excuse me, submitting third-party claims on their behalfs, and we'll certainly get into that as well. But to the extent that a pharmacy is giving a third party the ability to submit any claims on their behalf, it is likely something that requires disclosure, if not is prohibited by several PBMs. The other thing that we're seeing a lot of is just a review into sort of all aspects of pharmacy. A lot of the times pharmacies go through an audit or investigation, they're like, they asked me this and they asked me that. I've never seen that, right? And it's just becoming more and more common, where you can certainly expect that pharmacies get asked sort of any and all questions when it comes to audits, and not just those specific to prescriptions and specific to invoices, especially when a pharmacy is being reviewed. Not only do they look at the audit, maybe in the findings that have led to the pharmacy being reviewed, they're looking at all aspects of the pharmacy's overall participation. Again, we don't know what triggers audits and investigations sometimes, right? But they're also looking into that as well. The other thing that we'll continue to see, is just mailing limitation enforcements post-COVID that have led to not only monetary recoveries, but issuances of cease and desist, as well as network terminations over mailing as well. Again, there's certain PBMs, many PBMs that have limitations on mailing, whether that's a percentage or whether that's just a prohibition altogether. And certainly important to understand the difference between what mailing is and delivery is. I almost see it as like the second that you break chain of custody, that is considered mailing, right? So if you have your own W-2 delivery, if you decide to hand it to Sam's courier service down the street to then deliver medications, most PBMs would consider that to be mailing. Again, this is going back to when we talk about claims phishing and third-party relationships. I briefly touched just upon this like just now. It has to do with the submission of claims using the pharmacy's NPI credentials. Most PBMs have limitations on another party having access to the pharmacy's credentials. Not only does that mean submitting test claims, that also means having visibility into reimbursement data. You can expect that PBMs are very sensitive as to who has their data. And if there's parties out there that the pharmacy has that aren't disclosed, that have access to the pharmacy's again, ability to submit claims on the pharmacy's behalf, but also reimburse claims level to be reimbursement data, it certainly could land pharmacies in a bit of hot water with PBMs. The other things that we'll see oftentimes, and what we're seeing a lot now, and I'm sure you guys have seen this, especially with, like, for example, AstraZeneca, is instances of where manufacturers have taken data that they've gotten from both wholesalers and then also PBMs to understand if a pharmacy has actually purchased sufficient amounts of their medication against the amounts that they've dispensed. And in the instance of where they haven't, issue demand letters of sorts that have asked pharmacies to correct the way that they've billed claims incorrectly, or potentially monetary amounts, not necessarily with AstraZeneca there. The other thing is that we'll see a lot of this happens a lot more with like diabetic testing supply manufacturers, like where we'll see that they'll suggest pharmacy didn't purchase from authorized distributor. As a result, we lost money based on our rebate agreements with PBMs, and so you owe us X amount of money. And so we'll see a lot of that happen, especially with manufacturers, and we continue to see that. We've seen that in the past, but we've seen it only certainly increase, especially in this year, especially with the round of AstraZeneca letters that we've seen over the dispensing of Persigo. Just really quickly, I guess, we touched on this it's just an example, again, when it claims to claims phishing, right? The submission of a test claim without an actual valid prescription, again, to understand what reimbursement looks like, so that, sometimes when pharmacies may be in semi-hub type relationships, to see if there's this instance of where a pharmacy could otherwise receive prescriptions, for certain medications, and then especially certain medications that are otherwise higher reimbursing. And so for that reason, we've seen a lot of PBMs suggest a pharmacy's been engaged in claims phishing, especially when a pharmacy may be submitting a lot of claims and then reversing a lot of those claims as well. It certainly flagged a lot of pharmacies. And not only has that subjected pharmacies to what PBMs have tried to do is a monetary chargeback, even though the pharmacy didn't actually get paid on a reverse claim, but certainly network participation, being revoked over those types of issues. And so it's really important, like I said, if you have a third party besides the PSAO that has any access to your data, that you're making sure that's otherwise being disclosed and being yet you're engaging with them in a manner that's appropriate and consistent with the PBM limitations and contractual limitations. In terms of, and shifting away, I guess, a little bit from audits and audit trends, some things that we've seen in terms of network trends, network participation trends, like I said, is the compounding of audits, right? If a pharmacy consistently continues to have issues in their audits year after year, that's certainly more possible that a PBM may be likely to terminate based off the basis of those discrepancies. For example, pharmacy continues to bill incorrect indices in the first audit, continues to do so in the next audit. That could certainly lead a pharmacy to being reviewed for network participation. And that goes into the second section of a failure to comply with previous corrective action requests or cease and desist notices, right? So if a pharmacy previously went through an audit and was expected or asked to engage in corrective action measures, or was asked to cease and desist from an incorrect billing practice, but then continued to do so in a subsequent audit, that only gives more of a basis for a pharmacy to be terminated according to the PBM, because not only have they continued to have discrepancies in their with their performance, but now they formally have also violated potentially a previous corrective action plan that they had agreed to entering into and maintaining, or they violated, a cease and desist notice as well. So certainly things to consider, again, as you receive multiple audits from PBMs. The other thing that we'll see a lot of, and we've seen, is the failure to disclose disciplinary actions. And the word disciplinary action for a lot of PBMs is very broad. And it's obviously very purposeful that they keep it very broad. But PBMs have requirements that a pharmacy disclose disciplinary actions to them. So that could mean an action based from your state board of pharmacy, could be the DEA, it could be potentially even from another PBM as well, to notify them of that action that's occurred. Most commonly, we see this with obviously the board of pharmacy. And so to the extent that your pharmacist in charge has potentially faced some sort of disciplinary action from the board of pharmacy, that could and will likely, depending on the PBM, require disclosure to them, to the PBM as well. And so it's really important to understand in what circumstances is a disciplinary action required to be disclosed, what the method of that disclosure is, and then also what the timeline for that disclosure is as well. Sometimes the words are a disciplinary action must be disclosed immediately. Okay, well, that's a bit broad. But then sometimes it must be disclosed within 5 business days, 10 business days. And so you have an expectation that you're making timely disclosures. And in the event that a pharmacy doesn't make those disclosures, and say at the time of recredentialing, a PBM looks into the pharmacy independently and identifies some sort of disciplinary action, it only leads to more grounds for termination of the pharmacy. We see it happen often because not only is a PBM then failing, not only is a PBM then terminating the pharmacy for the actual underlying action that's occurred, but they're also terminating them for a failure to disclose and meet their contractual obligations as well. And lastly, the other thing is to failure to disclose common associations. Again, when it comes to common associations, a lot of the times, it's really important to understand what common affiliation and ownership is. Sometimes that could just mean, you as an individual owner owns another pharmacy and that association or affiliation must be disclosed. Sometimes some applications, especially when credentialing, also ask you, do you have any family members that own other pharmacies, right? And so it's really important to make sure that you're disclosing in as accurately as possible when you're going through any sort of credentialing or you're updating any sort of credentialing documentation.
Thanks, Harini. So here, failing to, again, like we've been saying, failing to challenge audit findings can lead to recoupment of funds for dispensed medications, compounding the loss of drug acquisition costs, like we discussed, cross termination of affiliated or commonly owned pharmacies. And again, PBMs can treat historical audit issues as demonstrating a pattern and extend those adverse actions across related entities. So, how does a pharmacy in general prepare to address an audit finding? So, it's best that pharmacies, we say, should adopt a proactive, not a reactive approach. And what we mean by that is staying organized, reviewing common audit areas, ensure staff training, conduct internal audits, prepare responses in advance if possible, and of course, document everything. So, regarding documentation discipline, it's important to maintain complete purchase histories, invoices, proof of payment, prior authorization files and documentation, patient consents, communications, delivery logs, signature logs. Keep those organized and retained for multiple years. As it relates to internal reviews, it's important to conduct periodic inventory reconciliations and targeted reviews of high dollar claims, specialty medications, known audit hotspots, for example, in recent months and the last couple of years, GLP-1s, high cost biologics. Establish and enforce policies and not just templates. So it's important to implement policies for inventory management, copay collection, financial hardship, all things we've already touched upon, auto refill authorization, prior authorization rules, FWA training, controlled substance management. These things, such as also delivery versus mailing policies. It's important to have policies and also training, staff training, to ensure that the policies are properly implemented, as they will often need to be refreshed, and refreshed training annually will help better align your policies to PBM terms and provider manuals. Additionally, where discrepancies are found, like we touched upon, document your corrective steps, the caps, and show prospective compliance. PBMs will often look favorably on implemented caps and may actually require them as conditions of continued participation. Again, it's important to not treat final audit results as the last word. Most PBM contracts and manuals provide for appeals of initial and final results, or at least allow for a dispute process. Even when it's not outright said, dispute resolution provisions often permit further engagement on any issue in general, which can affect your audit outcome. And it's, again, important to exhaust administrative appeals and have formal contractual disputes to preserve your rights, correct the record, and all of this is in an effort to ultimately reduce any risk of termination. As we mentioned, multiple audits can compound, and the risk of that compound is real. So again, even small findings, particularly those with non-compliance and high-risk categories, if they are often found to be reoccurring, they will be used against you and can be made to justify a termination, and will be used to argue material breach or a failure to remediate the issue.
So sorry, Ben, I was just going to
No worries.
just jump in. Um, when you mention policies, and it's great that you mentioned that, because a lot of the times folks have draft policies and procedures and don't actually fully implement them in their into their pharmacy, and they have something about they have it typed up, but really they don't actually have anything actually implemented. And so it's really important that you're making policies very specific to your pharmacy's operations, especially if you use one from a third-party consultant or a third-party service, that they're really tailored to you and your pharmacy's operations, and that your staff, especially now when I know that turnover for a lot of pharmacies is high, to make sure that your new employees, your old employees, are very well versed on what your policies very much are, as a pharmacy. And we see it happen so often, of where folks suggest that they had a new staff member that wasn't aware of X, Y, and Z, and so this is the reason that that's occurred. And so it really is important to make sure that you have staff that's well versed on your policies and procedures, and that you have them implemented as well. I know the slide is related to policies and procedures, and so I just wanted to make sure that I certainly mentioned that. So go ahead.
No, absolutely. Thank you. And to your point, we actually have seen recently a matter where there was a client who had a policy that they implemented, I believe, on their own, that was more strict than possibly the PBM would have asked for. And in their audit findings, the PBM said essentially that you didn't follow your own policy.
Mm-hmm.
So it's definitely important to look through these policies regularly, annually at minimum, and ensure that everyone's on the same page and that the pharmacy is actively abiding by those policies.
Some of these are the policies and procedures, right, that we think that certainly almost every pharmacy should have have a copy of, and a process by which they follow.
Yes. So with that, I'm going to turn it back to Harini, who will touch upon available legal tools in your effort to address appeals.
Yeah, thanks. And this is certainly important for a lot of pharmacies who receive audits, receive any sort of, almost have like any sort of interaction, honestly, with PBMs. And I say that because, you have a lot of administrative ability in certain instances, obviously, to address an audit, right? You'll receive preliminary findings. You'll be given a certain audit period window to be able to provide a response back, et cetera. But really, what happens when an audit's finalized? What happens when you're terminated and you've exhausted your appeal rights under your provider manual? You do have, and most PBMs do allow for a dispute resolution process under their provider manual. Truly, it is a step before a pharmacy initiates either arbitration or litigation, which is typically determined based on the contract of the PBM. Most PBMs, I will say, allow for arbitration. Certain PBMs require litigation. But even though it might be considered, the dispute resolution process might be considered a step before arbitration, we often do see it as an ability to engage in a secondary appeal discussion of sorts with PBM councils or PBM network teams to be able to engage in a discussion really aimed at resolution. That's what it's intended for, right? The dispute resolution process. We certainly hope that when we engage in that process on behalf of pharmacies, that it's reciprocated in terms of their cooperation, their willingness to resolve things. And so, to the extent that you ever receive final audit findings or final determination on anything from a PBM, I always like to think of it as don't consider anything final, just as Ben mentioned. And you certainly have contractual ability to further engage in a discussion with PBMs. Again, most PBM contracts, major PBMs do certainly have dispute resolution provisions. The other things to keep in mind are prompt pay laws. This is especially important when you're not receiving a sufficient, not sufficient, reimbursement, on time pursuant to your agreement. The other thing could be where it could be used is if you are experiencing any payment withholding far in excess of, say, an audit amount. Typically, PBMs do have the ability, retain the ability to withhold in the event of an audit. Sometimes your PSAO may even do it proactively if they're aware of an audit's coming through. But there are, again, certain laws, prompt pay laws, that allow you to challenge withholding, especially if it's in excess of certain audit amounts. The other thing is you do have any willing provider laws, which essentially suggests that as a pharmacy that is willing and meets the reasonable and relevant terms of a network, that they should be able to otherwise be allowed in the network and be able to continue their participation. And I think someone dropped this in the Q&A when it came to fair audit laws, is really what other states could New Jersey look to mirror their own fair audit laws. New Jersey does have some audit protections, but I will say that it certainly could be an instance of where they get expanded upon. And we can skip the any willing provider law. Like I said, New Jersey and New Jersey certainly has one and should certainly be leveraged in the event of a pharmacy facing network participation. But when we speak on fair audit laws, again, it certainly does have one. It certainly could be one that could be strengthened for sure. There are some states that have very detailed fair audit laws. I will say almost every state has a carve out for fraud, waste, and abuse, meaning that even in the event of an investigation, a fair audit law wouldn't otherwise be applicable or protect to pharmacy if the PBM decides to allege FWA, right? And so there are certainly issues that we see with fair audit laws, especially in the event of investigation, right? Because PBMs are using investigations as a way of circumventing fair audit laws. So in the event that you get hit with an investigation, it's still helpful to allege violations of fair audit laws, but it certainly does weaken a pharmacy's position because at that point of PBM's alleged FWA, and there's usually a carve out for that as well. The other thing, I know that, like I said, we do have a Q&A here, and I know that we gave ourselves a couple extra minutes and did go through some of these slides here quicker at the end here. But we do want to give anyone a couple minutes if they do have any questions, and we'd be happy to answer them. I do see that someone had asked, can we hold the PBMs accountable for their fraud, waste, and abuse? And I would say that, There's a lot more exposure, obviously, to PBMs now that we've seen ever before, and that's certainly great to see that a lot more pharmacies, especially independents, are becoming a lot more involved in those conversations, especially in the state of New Jersey. I know that a lot of folks are involved in sort of those bigger conversations, and sort of just the way that our the way that their relationships are with PBMs. And so the one thing I can say is certainly it helps to be a member of an organization such as NJPHA, any state organization that's certainly aimed at holding PBMs accountable, whether that means, through a more aggressive approach of litigation, right? There's a lot of class actions, like for example, out there against PBMs for reimbursement issues. There's a lot of legislative efforts, of course. There's a lot of instances of where we'll see states have been regulating PBMs a lot more. And so, the most we can hope for is that those conversations continue. And so that, we do hold PBMs more accountable for their FWA, because we are very much aware of the fact that obviously PBMs, do have their own internal issues, and the issue of vertical integration across the industry remains an issue for a lot of folks. And for obviously independent pharmacies, that's certainly a big concern. But with that, it doesn't appear that we have any other questions, but our contact information is here, both mine and Ben's. If you have any questions, you can feel free to reach out. Feel free to send us an email if you'd like to just be updated. We do send out newsletters on the regular. So if you'd like to kind of understand what trends we see, not only on the audit side, but of course on regulatory issues, et cetera, we do put a lot of content out there for our pharmacy clients and just, pharmacy providers generally, if you'd like to continue to stay informed. And as Ben said, it's great to be proactive rather than reactive. And by joining this webinar, you guys are already taking that step there. Thanks, everyone.
Thank you.